Every day, citizens around the country are faced with new dilemmas. Dilemmas that affect them profoundly. Whether it's injustice, discrimination, falling through the cracks, scandals and cronyism, balances of power, ethics, religious freedoms, state versus citizens, and unfunded mandates, and the list goes on and on and on. Welcome to Speak Up. It's directed at those who have fallen through the cracks, and it gives them a voice. It's your turn to speak up, to stand up and fight back. Thank you for joining us for another episode of Speak Up. Today's program is about Dcyf, Division of Children, Youth, and Families, another state agency which is being called into question for some of their practices. This agency has come before the Redress of Grievance Committee here in New Hampshire. And as you'll see on today's show, we've uncovered the fact that they get an F as far as our rating scorecard amongst all the other states. Today's show is also about an individual who helps people to come before the Redress of Grievance Committee and helps them with their facts, get them lined up, get their information so it's ready to be presented. I hope you enjoy the show, and thank you for watching. And I'd like to introduce you to my guest, Denise-Marie McIntosh. Welcome to the show, Speak Up.
Thank you, Kevin.
Well, for our guests that are our viewers, I just want to let them know that you are an independent paralegal.
Yes.
Okay. Can you tell me a little bit how you came about, just a little history on what is an independent paralegal and how you actually got involved?
Okay. Well, I became a paralegal due to a contentious custody battle in the courts in New Hampshire. And I went to school just to find out what happened in the case, what went wrong, how it went wrong.
What clued you into it, the fact that something was going wrong?
Well, I was accused of neglect, but in so much as that, I was told that I had an inappropriate conversation once with my son about hurting members of his father's family. And it just wasn't true because at the time I was a foster parent for the state as well. And It would be crazy because I would lose my job as a foster parent, or one would think I would lose my job. In going through the process, I found out what my rights were. I found out how they were abridged. I was finally allowed access to my records from a 2006 or 2005 case 5 years later in 2010. And I could show the breaches that occurred. And while I was in school, I got involved with legislators to find out more about the process and changing laws, because one of the main things that came up was that at first contact, under the 169C, parents are supposed to be informed of what their rights are. You know, that...
Now, 169C, that's a state law?
The 169C is the Child Protection Act for the state of New Hampshire. It's about 38 pages long. It's lengthy, it's in-depth, and it has procedural safeguards incorporated into it so that what happened in my case, and unfortunately hundreds of other cases in New Hampshire, it's not supposed to happen, but because these procedures are done behind closed courtroom doors, there's no accountability.
Right.
The only way that I could fight back and regain custody of my son was by going to school for paralegal studies. I was granted a scholarship to attend law school, and I was just accepted to the Massachusetts School of Law starting next year.
Congratulations.
Thank you. But I do not think that parents should have to go to school to find out what happened in their case.
Well, we're finding that in the Redress of Grievance Committee, how these fathers and mothers and grandparents, Dot Knightley, she knows her case inside and out. She knows the law inside and out because they were forced to. They're forced to become extremely familiar with what went wrong. Why are the courts violating this statute and this statute and this statute and this law and this law? And they're shaking their head saying, why can't I see my kids? I've done no wrong.
Exactly. Well, and the other thing, too, is that not only with the state law, there's constitutional issues and there's federal law that backs it up and makes parts of this law stronger. There are still parts of it that really hurt parents. For instance, in 2007, when I started school, I went and talked to different groups, women's groups, actually any group that invited me, and told them about problems that I was seeing within the system and asked if anybody else had the similar problems. And I collected a petition of over 80 names that I gave to a family law committee, names, addresses, phone numbers, and emails of people that did not receive their rights at first contact. They didn't know that they didn't have to talk to DCYF. They didn't know that they were entitled to records. They didn't know that there was an ombudsman's office to go to when they had questions or concerns about how their case was progressing.
Let me interrupt you real quick now. First contact, what is that?
First contact, when a DCYF worker suspects any type of abuse in the home, at first contact, they're supposed to inform you that they're doing an investigation. They're supposed to tell you what your rights are, and they're supposed to tell you that you have a right to an attorney. And now they do not give court-appointed attorneys as of July 2011.
I wonder why.
The judicial committee, the judicial branch, I believe, put it in on another bill to get something else passed. They included it, but there is briefs in the Supreme Court now that show parents are entitled to an attorney because they're going to lose a constitutional right. You have a right to your family.
So what you're saying is the judicial branch put in a bill.
Or they attach to another bill.
Attached to another bill, the waiver of a right to an attorney?
Yes.
So if DCYF comes knocking on your door, the first contact, they're supposed to inform you of your rights and that you have a right to an attorney or a court-appointed attorney?
No, it used to be a court-appointed attorney, but they took that right away.
That's what I'm trying to get at.
Right.
They took the court-appointed. So if you're poor,
right,
and you do not, or it doesn't matter if you're poor or if you're rich, if you
don't understand the laws, that at that first hearing, the social worker is going to create an affidavit of the people that she spoke to. You may not get that affidavit until a couple of days before or the weekend before. They're supposed to hear it, I believe it's within 5 days, but that it often happens quicker, putting parents on the short end of not having an attorney present, not able to contradict the information right up front, not understanding that they can bring in their own witnesses. And in fact, because these are closed-door proceedings, a huge number, at least 23 people that I spoke to, were not able to bring in witnesses on their own behalf. They were denied.
On what basis?
The judge just denied it. No, we're not going to allow it.
Okay, so what's going on here? We're seeing over and over again, there are abuses of systems throughout the court systems, whether it's DCYF, whether it's the guardian ad litems, whether it's the marital masters. There appears to be a lot of problems. Today, we're focusing on DCYF. Can you tell me what are some of the systemic problems that are killing, crushing families, parental rights, if you will?
Well, I think it begins at the beginning. Well, with the law, anybody, your neighbor, the person across the street, the person who you see in a parking lot, could call DCYF and complain that you're injuring your child in some way.
Just to get back at you.
Just to get back at you. If you talk to psychologists in Nashua, just Nashua, who work with people that, live on the tree streets, they'll tell you that it's a weapon that women in those areas and middle-class areas are using against other women. And they'll call and they'll make a false report. Some are returned unfounded, some are founded. Some of the ones where the child really needs help, they're not getting it.
Right.
So they're not doing the research, they're not following their own protocols on investigation. So when you get into the courtroom, there's an affidavit, you have no idea what it's about. and they don't have a lawyer to represent them. The other thing is, when they did have lawyers to represent them, in half of the cases that I reviewed for the Redress of Grievance caucus before it became a committee, showed that it was the attorney's fault. And the reason that it's the attorney's fault is because they have no experience. So going to law school myself and understanding the legal process and sitting in on numerous court hearings, I can go to bankruptcy court, I could sit there for 2 days and I could get a year's experience. If I want any experience in a 169C case, my experience is on my first 10 clients, because that judge will not even allow me to sit in that room as an attorney or as a law student to understand how the cases are going. Moreover, you have no access to the records.
Why?
They're all confidential.
So when we went to put in a bill for 415, which was a House Bill 415 to allow sealed envelopes, at least for the parents to at least understand what they're being accused of, we won it in the House, and somehow it died in the Senate. Why can't parents find out why they're being accused of something? Why can't they see that information?
Because the courts in Dcyf are not allowing them to, and without a lawyer pushing your rights and the federal laws that support that, you're entitled to know who your accuser is.
Correct.
That's the first line of due process.
But not in New Hampshire.
No,
Apparently.
but federal law, so you have to have attorneys that will push it for a family and get it recognized. You know, effective judicial procedures are supposed to be provisions of this chapter. And it's supposed to recognize and enforce the constitutional and other rights of the parties, assuring them of a fair hearing. How can you get a fair hearing when nobody can look at what's being done? There's no accountability. Talking about my own case, I was not entitled to, what happened was that my ex-husband had hired a psychologist to come in and say that the child said, the mother said, you know, that to hurt members of his family. He was 6. What could he have possibly done? Right. And then on top of it, it went through the process. He lived with the father for about a month before they finally interviewed them. Interviews are supposed to take place within 5 to 7 days per statute. Over a month later, they finally interviewed the child, who had been living solely with the father during their investigation, or alleged investigation, because she only talked to about 4 people. So we go through this whole process. They stretch it out. It's supposed to be a year. They stretch it out for 2 years. So in 2007, I'm like, well, I want my records. They won't give them to me. So then I worked with the Redress of Grievance committee, and I used the state reps I was working on to come in, and I'm like, I want my records. They want you to let me have my records for a statute. And I finally got them. Right. But like, each parent has to go and find state representatives to support them to get the records. That's just unconscionable, because everything shows that parents are entitled to these records.
What are you showing me here, right?
This is a table. This is a statement of a case that shows all of the cases involved, that show a parent is entitled to records in their case. So it mostly falls back.
So they have RSAs on there, and
right. This is actually, there's different things. First, you have your state law that you go by. Then you go to constitutional law. You reach out to other states to find supporting documentation, but those are more like secondary sources. So case law, the United States is compelling, then New Hampshire. There's Alaska.
Yeah. So,
but then you go to the tables and statutes of other authorities in our own state that support. The Child Protection Act under 169C shows that consent orders, filing reports and evaluations, everything shows that parents are entitled. And we have a standing order.
This is invaluable for people who want to go before the Redress of Grievance Committee.
Right.
One of the things that I see that we're having a difficult problem with, people are coming in, they don't know what hit them. They've been at it for a year or two, and they're at their wits' end because they feel as though they've been violated. They've been separated from their children. They have mountains of evidence, stacks of evidence, and then they say, here, this is our problem, and you need to fix it. And for the committee to look at this pile of paper and say, oh my God, what do I do with all this information? What am I looking for? Can you narrow the scope of our investigation? Can you index it for me? Can you show me where the courts violated your rights or your due process? This helps them.
Absolutely, because when I work with
Did
clients...
you create this?
Well, this one is one that they can actually probably get access to because it's in the Supreme Court now. But it talks about, you know, however inartfully pleaded that somebody puts in their, a pro se litigant puts in their petitions and motions, it's supposed to be held to less stringent standards than formal pleadings drafted by attorneys.
Okay, what does that mean?
That means that when attorneys go in, they're supposed to know the laws, they're supposed to know your rights, and they're supposed to be clear-cut and point out all the discrepancies.
Okay.
So when a pro se person goes in, they don't have a grasp of the legal analysis.
Right.
They don't understand the 169C to begin with because
when
it
you
is,
say
it's
pro
a book.
se, that means you're doing it by yourself.
Yes, I'm
Okay,
sorry.
that's fine. No, some people don't know. So,
Which is a very large percentage. I think it's into the 80%
right.
tile that
Because people are either
somebody will
broke?
be a pro se litigant. Right. They're broke, attorneys are expensive.
Right. We've talked to one case, I was talking to one case actually last night where the individual went to his attorney and the attorney said, listen, this is what's going to happen. They're going to write letters and motions and more letters and more motions, and they're going to beat you down because I have to respond to every one of these until you're broke. And that's how they're going to beat you.
Right. And with court-appointed attorneys before, they paid them $60 an hour. And unfortunately, a lot of them were real estate attorneys, new attorneys that didn't understand the process. But now, having been through it myself, on both sides, I was a foster parent, so I had already fought for a child's rights to the education of her choosing, you know, and fighting for my son's rights, just to be able to see his mother, who had no criminal record at all, nothing.
Join the group, right?
Right,
Yeah.
and but then learning the law, and I went to Nashville Community College under the direction of Professor and Attorney Lubitz, who is, it's like going to law school, I suspect, because he's very tough, and he makes you really understand the law, the limitations, and the expectations, and what should be done. But if you don't present your argument well and you don't have all your facts in order, it's impossible to do. But in these types of cases, there are specific laws that I've labeled on my site that people can use to show that I'm pro se. You need to give me a break. I'm giving you the facts as I know them, and you know the laws. They're supposed, and actually in one of, there's a judge in Massachusetts, I used to be on the Massachusetts Supreme Court, Judge Richard Amy Cutter, and he was very big on the facts and, you know, justice. There's supposed to be justice for families. And the child judge should then go back and inform the pro se litigant of the proper procedures for the actions that they're attempting to accomplish.
Right.
There's laws on that. The statute of limitations for parents trying to enforce a previously ruled on motion for discovery against the Department of Children, Youth, and Families. I mean, they have an order that they're supposed to release discovery, and they're not doing it. You know?
If somebody wants this document, if they're feeling as though they need a grievance or how do they get this? Can they get that from you?
They can get this from me.
Okay. How do they do that?
They can email me at dmvc@comcast.net. They can look at my blog on DMVC Results Blogspot.
Well, we're going to take a quick break, and we'll be right back.
Okay.
And we're back with Denise-Marie McIntosh. And Denise, what I'd like to know is, when somebody wants to go before the Redress of Grievance Committee, how should they be prepared? What should they have? I mean, I sit on the committee, but I find it very frustrating when they have all this information and it's not documented in the proper way. I mean, they have their documentation, they know it, but how can we help them help us, or
Well, I think
help me?
all right. Well, if I was briefing a 169C case, the Child Protection Act, for an attorney or a pro se litigant, with pro se litigants, the attorney can give legal advice where I can't give legal advice. I can definitely, if you tell me problems with your case, I can find case law that might mirror it, but it's up to them to use what they want. But it helps them to explain what went on in their case. So, for instance, first, to brief a case, you're going to write a brief citation, which is the name of the parties, the volume number, the abbreviated names of the reporter, if it's in a reporter, if it went to the Supreme Court, the page number in the reporter where a case begins, and the year of the decision. But then we're going to gather the facts, the relevant factual background to the case. What happened? How did the parties initially get to court? What brought them there? And then we'll go through the procedural history to see what procedural issues and decisions came up in the case. For instance, a decision that was made on motion by a lower court. Did you ask for records and not get them? Oh, well, these laws seem to indicate that you're really entitled to those records. So let's list these laws first. We'll put that in. We'll put your motion in that shows that, and the order that shows that you were denied it. And we'll let the legislative group look at it and see if they feel that it's contrary to the, so you're basically doing the same job as an attorney on the legislative committee,
Right.
But it helps you because you're all not lawyers. So you don't know the laws that are affecting these people or how they're affecting them. Or, we'll put in there, in the affidavit, it doesn't even say that they gave you the handbook. Do you have anything that you signed for this handbook? Because they have to sign for it.
We're hearing over and over again, motion denied on a number of cases, whether it's a motion to introduce evidence or on many levels.
So then we need to put those orders in date order of how things progressed in the case, and we start backwards and work to the beginning. So we'll show a motion to deny. Was there substantiated reasoning? Did the judge have substantiated reasoning and say, well, we're not going to accept this because this offsets it, or we already have this? Why isn't it relevant for a parent to hand in that type of evidence? And then we'll look at some of the laws. We'll look at the 169C and say, well, it says that it should take any evidence. So we're going to put a copy of that piece in front of those documents to make it easier for the Redress of Grievance Committee. Or another, if I'm briefing a case with a pro se litigant, sometimes they've been through lawyers, sometimes they've tried to go pro se, all of a sudden they find that they need an attorney or they just need bundled services, which means that an attorney will act for them on one motion or go to court for them on one issue. So they want to put all the records that are pertaining to that issue in order, so I'll help them get all of that in order. And laws that might affect it, I can't tell you for sure that they do, but I can tell you that these are laws that might affect it, and I'll help your attorney, come down to a better analysis. And then after that, what are the legal questions that we're asking the court to consider? Is a parent entitled to these records? Is a parent entitled to put evidence in? And then we look for the answers. And I show them how to look on the site. For instance, on the Supreme Court site, the Family Division has some standing orders. So it'll say standing orders. It's on the very bottom. It's really small. You have to look for things. But effective immediately as of 12/12/06, the protocols relative to abuse and neglect cases and permanency planning, all the forms, are hereby made mandatory in the judicial branch district courts in New Hampshire. This order is made pursuant to Supreme Court Rule 54 in order to manage the case flow and to assure the timely disposition of the matters addressed in the protocols. But if they're not following their protocols, then you have to go to another research.
Well, now, one of the things that the Redress of Grievance Committee asked DCYF, are the protocols available? And they never answered us.
They
But
never answered you because
No.
they're online.
And but they didn't point anything out, and apparently you have them.
Yes, it requires a bit of research because...
And these should be readily available to the people.
Right. But if you want the web address, it's under www.nhacac.org/PDF/2008_AGS. If they go onto my site, they can get the whole thing, but it's
Right.
Protocols on Child Abuse PDF, and they should be able to find it.
But you have to do all this research to find out their protocols? Shouldn't this be in a booklet handed to the parent right away?
This should be readily available on their own website.
Right.
And it's not. It's hidden. There's also, when I did it...
Do you think it's hidden intentionally?
I think it is. Well, just my
When you say
personal...
hidden, that automatically says, wow, it's hidden. Here's the rules, and we don't want you to know that they're there. That's,
Well, they have, for instance, they have...
they're not readily found.
They're not readily found.
Okay.
And they don't make it easy for parents to find the information they need to get through the system.
Okay.
But it tells you, in this protocol, it gives you the laws, it tells you what your rights are. It tells you the procedures for reporting child abuse. Who has immunity? You only have immunity if you tell the truth. Now, if a social worker decides, like in my case, and she testified, so I have it on record, but at the time, I was a stay-at-home mom. My ex-husband was a teacher. There was a doctor who was a psychologist licensed by the state of New Hampshire. She's like, well, these two individuals are licensed by the state of New Hampshire, so I believe them over you. And that's all it comes down to. And it was just like, but you didn't check your evidence. In your affidavit, you stated that the psychologist said this on this day, that the child said this. And she's like, yep. And I'm like, well, do you take good notes? And she's like, that was an answering machine. So I'm like, okay, so then it's pretty much what she said. She's like, it's exactly what she said. And I'm like, okay, so then
Did she lose her immunity as soon as she contradicted herself?
No, because then I said, because part of it's just stupidity. They don't train these people. And she turned the page. I said, well, could you turn the page? And when she looked at it, I said, so you believe this therapist, so you believe she told you the truth. So you would expect to see that in her own notes with the child for that day. And she was like, yes. And I'm like, could you read to the court what this says? And it said the child didn't want to talk about the mother today, so I didn't push him to do so. I'm like, so it's pretty inconceivable that she told you the truth. And because you never checked her records, which your protocols call for you to do, they call for you to check a doctor's records because doctors have a lot of patients. They can make mistakes. They can get people mixed up.
Right.
She never checked the records. Otherwise, the case would have been done then. And that's what parents need to know. They need to know that if somebody is, talking against you, you need those records. You're entitled to those records to dispute what they said. In this case, the psychologist obviously lied. So, then you have to go for a civil suit later. But it's ridiculous. When you go back to those issues, you go to the applicable rules of law. Most of the rules and laws and cases that address these issues are all here. Their response time, how they're supposed to report, reporting to licensing, interviewing, the alleged home visit observations, collateral, how they're supposed to do their investigation.
Now you work
how they're
outside,
supposed to collect evidence.
You work even outside of DCYF as well also.
I used to work for DCYF as a foster parent.
Okay.
So at the time...
You're very familiar with the ins and outs.
Very familiar. I also grew up with 13 foster brothers and sisters in Massachusetts and fought for their right to have an attorney represent them.
Right.
In New Hampshire and in the United States, children have the same rights as everybody else. And they're entitled to a lawyer.
Right.
So in the 169C case, the 169C recognizes that a child has individual rights, but those rights cannot be upheld if they're given a CASA worker who is a volunteer. you know? The only way their rights can be upheld is if an attorney represents their interest.
Are you familiar with the Knightley case?
Yes.
What went wrong there? In a nutshell, I mean.
In a nutshell, you had a young woman who got mixed up with the wrong crowd. As soon as she found out she was pregnant, the records show that she went to, she did everything to have a positive pregnancy and protect the well-being of her child. She checked into methadone. And then she had a lot of problems that were overlooked, I believe. And I have not looked at this case for several years now, since I reviewed it for the redress. But
didn't DCYF just come in and send out the kid for
as
adoption?
As soon as the child was born, it was like the Irish case. As soon as the child was born, they said that, and one of the records said that they believed she would do harm in the future. Well, the law is this isn't a Tom Cruise movie.
Right.
These are people's lives. And you can't project what anybody is going to do in the future. What did she do in the hospital to endanger this child's life?
Right. And they didn't contact the other family members to place the child,
No.
which is part of the law. It's a federal law.
Right, and that's the other thing that kills me. When I researched and talked to the deputy commissioner in the Department of Children, Youth, and Families in Baltimore, Maryland, I asked what they did immediately. And I checked with several social workers in the state, like, how often do you, how do you look for families' information? I'm like, I don't know. If they tell us. And I'm like, really? So I talked to Maryland, and the simple thing they could do, every child, even if they're homeschooled, has emergency contact information.
Right.
All they have to do, they have access to that. All they have to do is get the emergency contact card, find out the extended family members, and, place them there.
That case is definitely a nightmare for them. They didn't contact the immediate relatives. They
didn't contact the relatives, as I recall. They didn't contact the relatives.
The uncles,
the grandmother, and I believe an uncle attempted to gain custody, and they were just completely shut down by DCYF. They never even made it into court, and I believe the grandmother put in a motion. And
right. Yeah, and it's kind of frightening at where that goes. And so she's denied custody of her grandchild. You adopted the grandchild out before you went to the grandparent.
Well, yeah, the records seem to indicate that the adoption went through before the TPR, the termination proceeding, ever went through.
Right.
And then there's another case before the redress with another family that had their niece and nephew in their care, and DCYF it was an interstate thing, and the social worker said, I'm going to find them guilty of neglect. So Massachusetts just dropped the adoption. But Maggie Bishop, who's in charge, could have went back and said, okay, well, after the investigation, our social worker was completely out of line, and we have no finding against this family. Can we reinstitute? She never did it. So they're still fighting for their children.
You have a report card.
Yes.
Now, New Hampshire's DCYF report card compared to all the other states, how do we rate?
F, you fail. The score is 58 on this report. On my site, you can also get connected to the federal audits. And over the last 20 years, both the federal audits show that DCYF is failing up to 66% of the people that it served.
Are they failing because they're lazy or there's money involved here?
I think they're failing on all accounts. Well, several of the cases that we reviewed on the redress showed that the DCYF workers did not do a proper investigation or interview all the people that they could have to find or ascertain the truth, so that children who should have remained at home didn't, and children that should have been put in foster care weren't.
So this is a type of judicial child abuse, isn't it?
I believe it could be looked at that way. For instance, here, the state law does not mandate attorneys be appointed for children and dependency proceedings. It doesn't define the duration of the appointment. They have a CASA.
We originally talked about the placement with DCYF, and you mentioned something about the placements in families or foster care. It was watered down because they average it out since 1978 or some. What were we talking?
There was one report that Maggie Bishop released.
Maggie Bishop being the
director of the Department of Children, Youth, and Families, and now she's the director of the Juvenile Delinquency. I think it's the JCC, but where the Sununu House would fall under.
Okay.
That.
And she filed a report saying, a watered down report as far as.
Right. She said, oh no, we're making changes, we're putting more kids in the home. And in fact, her statistics, if you really look at the small print and time frame, show that, no, these are the people that you sent back home, you know, since 1979 when you were established. They don't send home the majority of the children that are taken out of their homes.
For
they
instance,
don't practice.
This year's, all the kids that went back home, or last year's, all the kids that
Right.
went home, they average it out over the long period of time.
Right.
Which isn't really an accurate way of looking
she did the same
at
thing.
it.
When you read, if you look at the reports, if you look at the federal report, you can see where they failed, and where they failed 66% of the children. Like, they didn't ensure continuous visits with their family members or siblings. And the Nashua office failed that. It's really bad. But then when you look at Maggie Bishop's report for the state, it includes all those same numbers and shows those failures, but she'll show it and she'll say, oh, we're making improvements. Right. You know, we made a 40% improvement, but it's like, no, you did it.
Talk to me about the federal money tied to DCYF and foster care.
The federal
money?
Federal money. That's interesting. I'm still researching that. Actually, and just wanted to point out that an attorney can be appointed as counsel for children under RSA 169C10, Section 2B, but only to compel the attendance of witnesses. It authorizes the provision of counsel during juvenile court proceedings as may be necessary to protect the rights of the child, but does not expressly guarantee that children will be represented by an attorney on appeal.
That's in New Hampshire.
Right, and they're not giving them lawyers, they're giving them CASA workers. And CASA workers are volunteers. Guardian ad litems are typically lawyers or others with a little more education than a CASA worker.
Well, there's problems with that agency as well.
Right, like right now they have a cap of $1,000. So they're supposed to notify the court when they're going to go over, not when they're over and charging parents more, but that's...
We just uncovered a case recently where, I believe it is in the Dow case, where the guardian ad litem happened to be friends with the judge. And then, well, you know, Your Honor, I need an extension, or I need to go over this $1,000 cap. But in the meantime, the guardian ad litem was charging above the allotted amount, and just going back retro and saying, Your Honor, I need some more scratch here.
Right.
And that happened over and over again to the point where he was paying $9,000.
In
the Vandenberg case, it's $35,000. There's cases up to $40,000 that the guardian ad litems are squeezing out of one side of the family. And somehow, in the Vandenberg case, he has to pay all of the guardian ad litem instead of splitting it 50-50.
Well, that part depends on the party's income.
But $40,000? The cap is $1,000.
Right, so it should never have went over the $1,000. There's specific criteria that the guardian ad litem should be looking for, and that's it.
So anyway, there's abuses on that as well. And I just wanted to talk about a little bit about the federal funding of DCYF and some of the potential incentives for them not to do a good job.
Well, here's the interesting part. In New Hampshire, in checking with other states, they have trust funds set up for children that are in foster care. In checking historically backwards, I've checked all the way back to when FDR has implemented it, the foster care system in general. But the purpose of this fund was to give children that were in foster care some money as a stipend for their, to get a car, to get an apartment, to enroll in school, some of those benefits. And unfortunately, over 25 years, I talked to a large amount of people that were in the foster care system, and none of them have received it. And sadly, the statistics show that these kids are living on the streets afterwards. They have no place to go because there's no incentive for the foster family to keep them. Some foster families are extremely nice, and they really help these kids get through college like I did, even though I had lost custody of my own son during the process, but not all of them. And I mean, and it's a hardship because, it costs money to raise children.
Where does the money go?
That's what I'd like to know, because in looking at the trust fund, in 2010, it was repealed. And now, the New Hampshire Children's Trust is a nonprofit. It's kind of, I haven't really gotten into how that could happen.
Should there be an audit of the trust funds?
There should definitely be an audit of this trust fund. It's administrative. It's as administrative as a designated fund by the New Hampshire Charitable Foundation or its successor or replacement. They're supposed to provide community-based education programs on prenatal care, but I've looked at parents' bills, which under this law they have to reimburse the state, but it's how much they can afford plus 4 years. So the amount of time that they have services, actual services, so that's in the Supreme Court now. Like, what's the actual date? When does this really start? The day they have services, or does DCYF count as services? And how are those assessed? So these bills are astronomical, anywhere like from $16,000 to over $100,000 for children's care in the system that we're receiving under Title IV of the Social Security Act. We're receiving a 75% reimbursement. No matter how lacklustrous a state's program is, they get reimbursed 75%, whether they're effective or not.
And that money's going into a trust.
Parts of the money appear to be going in the trust. Since they changed it to a nonprofit,
is it a private nonprofit or?
It's a private nonprofit.
How does that work?
This is what the interesting part is. I'm not sure how it works because it looks like multi-layering. So you get this. It says interest means the income from whatever source earned by the fund, exclusive of capital gains, which shall be added to principal. So the net of the bank management fees and administrative expenses incurred by the New Hampshire Charitable Foundation in connection with the investment and administration of the fund. So that's one layer. And then
who's administering these funds?
The Children's Trust Fund. It has to certify to the Secretary of State, the State Treasurer, and the Director of the Office of Legislative Services that the trust has been formed as a private New Hampshire voluntary corporation and has been qualified by the Internal Revenue Service as a Section 503C3 entity, meaning it's a nonprofit, which is really easy.
So government funds are going into this private fund, private charitable fund.
Right, and then it's being given back for community-based educational programs, programs relating to aid to parents, child abuse counseling, support groups for families at risk of child abuse, neglect, all the services that DCYF purports to give. So then, this is interesting. So then,
but if I might stop you right there, that money is actually designated for those kids back in FD, for those directly to go to the kids that are in foster care to help them move along, rather than to these support groups.
Well, that comes under a different section. So if you look at the federal funding, and it'll show that New Hampshire received, whatever, maybe a little over $2 million last year, or in one section, for services and family. And the new disclosure site by Governor Lynch shows that they spent in child and family services, which federal government shows they received funds for. You know how much they spent? Line item shows $0.
Where did the money go?
I don't know. They said, well, we could have put it under a different line item when I called. And I was like, you're supposed to match.
It sounds like the House needs to have an investigation.
Right, because, and I had brought in more evidence for that before and showed that, look, you can't explain where the money's coming from or going to. You know, you're only showing disclosure on what you're spending, not what you're receiving to spend. And then I have records that show that parents are being charged 100%. And if they're divorced, they're each being charged 100% of those bills, on top of what the federal government went. There's no deduction for anything.
And it goes into this private charitable?
It goes into this.
It sounds like it's...
It looks like it all funnels together. And
it's interesting.
but it says this fund, the New Hampshire, and this just changed in 2010. But from, I believe it was about 1983, it was started. But it's a special fund to be known as the New Hampshire Children's Trust Fund.
So you're still investigating this?
Right, because then it says that the private shareholder in this company, how can you have a shareholder in a nonprofit? Is the state of New Hampshire. So the fund makes regular payments of interest as defined in New Hampshire RSA 169C39B, Title VI. The New Hampshire Children's Trust Fund Board for programs, whatever, said money shall not be available for any other purpose. So it's to be administered as a component fund of the New Hampshire Charitable Foundation. And they said, when I called them directly and talked to them, because I disputed one of the, if you look at my site and you Google New Hampshire Charitable Foundation, they disputed an article that they wrote that I disputed. And they're like, come in and talk to us. I'm like, well, just explain how you're only a component when you're covered on, what do you cover under the 169C? They're like, nothing, that's not what we do. We help and give services forever. And I'm like, you're under the 169C, you have to have something to do with children, you know, with that. But this is interesting too. It's all in the law.
Can I ask a silly question? I mean, is this like a slush fund or a laundering? I mean, could somebody construe it? I mean, just at a quick glance.
And I'm definitely not an attorney, but looking at it, it looks like multi-layering, because you have, you know, parts where the state's receiving money, they match deposits.
And how do you track it all?
Solicitations. Yeah, but if you have 5 layers, that's kind of multi-layering. That's kind of money laundering.
Well, that's a crass way of putting it, and I know that's very crass. But the reason I say that is, the more you multi-layer it, the harder it is to track, and it then becomes. It almost becomes like the Matrix. Like these kids become, you know, a way to generate money for a lot of these state agencies. And it seems they're insulated from the people. That's one of the reasons why the legislature passed CACR 26. I know the Democrats are fighting it. But
what was CR?
CACR 26 is actually to hold the judicial branch a little bit more accountable to the rulemaking. We want the people to have the ability to challenge the court rules the way that the founders had it.
And I think that's a great idea, because with the Judicial Committee, they're all lawyers, or they've been at some point, so they understand the laws. And the laws and the rules have just gotten so out of hand that most litigants, the average citizen, can't understand what they're talking about. You know, even as I go through school, there's more and more things that I'm like, well, if the law says this, why are you doing this? I don't get it. You know, and I'll just call them on it now, because what else can they do to me? But
one of the things we're finding also in our committee, it's party lines. Though you show all this evidence, the Democrats don't want to hear it, and they become angry. And today they were challenging, and they're accosting, basically verbally, one of the people that are redressing and saying, listen, the courts violated this and they did this, and it's as though you're attacking their God, the state. And I hate they use that type of term, but
I don't think it's all Democrats. I think
in our committee it is.
It might be.
They vote consistently against the people that have redresses. I don't think it's all them, but the people that are in the state reps, they ran on accountability, they ran on transparency, and just the opposite's happening. People are saying, here's the evidence. And they're saying, well, that doesn't convince me. You could be lying. All right, now where do we go?
Exactly.
You know?
Well, that's the problem. There's no transparency. I think the best part about the Judicial Committee and legislators working together on the rules is that not all legislators are lawyers. So
And they
if a
shouldn't
rule, right, and that's the beauty of New Hampshire. There's 400 of you. So we get a lot of different personalities, a lot of different understanding levels, a lot of different competency levels. So by working together as a team with the judicial branch, you know, you can come up with rules that the public can understand. And if you don't understand them as legislators, why should we?
Right. This CACR 26 was actually a compromise between the judicial, the Supreme Court justices came in, the Senate, and the New Hampshire House. This allows the separation of powers to remain, but yet they have to interact with each other.
Right.
They have to.
It's a checks and balance
The
system.
people have to have a say, and if they don't, then it becomes an oligarchy, or something to that, or
Right.
an autocracy, or something to the effect where then the judicial branch of government runs everything, and they're insulated from the people. You have to have that interconnectedness, and yet the separation of powers at the same time.
Right, like you know, the judges need to have the ability to make laws, and you know, they're going to
Make laws?
well, not make laws, but make case law. You know, they have to have the ability to interpret the statutes.
Right.
You know, and sometimes legislators just have to learn to write them better.
Well, that's true. That's true.
But you know, they have to have that sense of immunity. But when it's clearly shown that again and again, particular judges are breaking their own rules consistently against a pro se litigant and not ensuring them of that extra protection as a suspect group, then, you know, I think you do have to do something.
Right.
Because, you know, we have to put, these people have to come in, they have to put together a citation of their case, the facts, the history, the issues, the applicable rules of law. They don't know. They have to look. Their objectives.
And that's what you do. You help people with this when they come to you.
Right.
Right? You're not an attorney, but you can help line up their facts. You can help them line up all their evidence.
Right, and I can help them with the search tools and the tools that they need to learn how to write a motion, to kiss it, meaning keep it simple, stupid. Don't add in all your heartfelt feelings. And as a mother, I know because I already made those mistakes.
Right.
And going to law school, you know, really helped me understand the judge's perspective when they're looking at things. And,
Right.
you know, yes, they get sidetracked and they look at a number of cases. But you just have to keep pounding, you know, the standing points and facts of your case, and then finding out, you know, what laws support it.
Is it true that the judges at some point only get the chance, if there's a marital master involved, that they only get 20 minutes to look at the whole case?
No, what I've heard from some judges is that, yes, we're supposed to review those cases by the marital masters, but do you really actually think we have time?
Exactly. So let's get your name out there again one more time to the people and your website. I'm sure it's on the lower thirds as we're talking right now.
It's Denise-Marie McIntosh. My website is DMVC Results. If you Google it, it should come up. My email is dmvc@comcast.net. And if you have a problem that, you know, you want to be looked at in confidentiality to bring to the attention of legislators, I do just create lists of people with the same issues, and I give their names, addresses, and phone numbers to the committee heads usually. So, like, you know, because not everybody can come into Concord to talk to you.
Right. And you're located in Nashua?
I'm located in Nashua.
Okay. And you basically help them get their facts together before,
Right.
and so that they can move forward.
And I show them where the resources are on the websites that they're harder to find. I show them how to read the 169C for child protection or the 461A for a divorce case, and how to work with their new setup where they have people in there.
Have you ever thought of running for office?
No.
Yeah, maybe we could use you up at the State House. So,
Thanks.
Thank you very much for coming on this show. Is there any
My
final
pleasure.
thoughts that you want to leave with our
No, I
viewers?
just think that you should look at the prevention program under 169C39A because it looks as if the purpose of the subdivision was to create a fund to be used exclusively for the prevention of child abuse and neglect. That's the first layer. In order to augment those funds currently available from federal, state, or local sources for this purpose, that's layer 2. Layer 3, what's intended? If they're giving out separate services beyond and you call the company and they don't know they're part of the 169C, I think that might be another layer. The investment terms that are in the statute itself, the private shareholder interest of the state in a nonprofit. Nonprofits aren't supposed to have shareholders and make money, are they?
Well,
I could be wrong.
we posed the question to our viewers, so let's see if somebody can tap into that.
Okay, and then the state treasurer is involved, yet this charitable foundation thinks it's completely separate. It's almost like a quasi-government department, but there's not enough in the law or the background of the company to put it all together. It just goes in too many different directions.
Well, let's see if we can't narrow our scope of investigation if it requires one.
Okay.
Well,
and
thank you. What?
Oh, and just the last thing, I just think that if people do have a problem with the system, they need to write to their legislators, and they need to let them know, because you can't fix a problem unless let people know there is one.
Right.
So I work as an advocate. A lot of times people just mail in their problems and information to support it, and I'll just bring it to different committees' attention to change it. So with the earlier, we talked about parents not getting their rights at first contact. By having over 80 people that took the time to speak with me and just sign a petition and tell us that they didn't receive that. When I spoke to the Family Law Committee and Dan Itzy, they were able to make that a part of the law, and it's unfortunately still not being done, so it's just finding a way to hold these people accountable.
Representative Itzy is one of the heroes up at the Capitol as far as one of the few that are fighting for family rights and a true advocate. So, Denise, thank you very much for coming on the show.
Thank you for your time. I hope I provided some helpful information.
Absolutely you did. Well, thanks for watching Speak Up, and I hope today's information was helpful. Denise McIntosh is definitely interested because she's actually been a part of the system and also abused by the very system that she's been a part of. If you need help, please contact her. Or if you have a story, please contact speakupnh@gmail.com. That's speakupnh@gmail.com. If you'd like to be a sponsor of this show, we welcome sponsors. Please contact me. Thanks a lot. Every day, citizens around the country are faced with new dilemmas. Dilemmas that affect them profoundly. Whether it's injustice, discrimination, falling through the cracks, scandals and cronyism, balances of power, ethics, religious freedoms, state versus citizens, and unfunded mandates, and the list goes on and on and on. Welcome to Speak Up. It's directed at those who have fallen through the cracks, and it gives them a voice. It's your turn to speak up, to stand up and fight back.